Fresh submission item number 1.
Effectively, your lordship, my lord. The petitioner has doing the plant culture in his own land, which is neither on the my lord shared nor within the Bhitarkanika sanctuary. It is 30 kilometers away from Bhitarkanika sanctuary.
No, but this is not a
At 60
matter.
My lord, registration is not at all necessary, but notice has been issued for demolition by
No. I'm saying this is a single judge matter, no?
single judge matter, my lord.
Ah,
Division
this
bench.
before the roster bench.
That these matters your lordships are taking up the my lord. Prawn carriage matter, my lord.
No, but-
Aquaculture.
No, but that doesn't. Unless
We
call for it, doesn't become a.
this bench is taking up my lord the matters.
No, but I think it was first taken up a single judge and then we transferred someone.
Yes. If your lordships, my lord, tomorrow your lordship post.
All right, list tomorrow before the roster bench.
Item number 2.
My lord, item 2, my lord. This is regarding, my lord, extending the benefit of revised judicial pay scale. According to, my lord, the Alok Mishra case, lordship have kept the similar matters, my lord. I was ascertaining in the morning on 24/8.
All
Similar matters are there.
All right. List on 24.
There's a contempt application, my lord.
Yeah,
It is
both.
listed today also.
Yeah.
Item number 3.
May I please, your lordship? On the previous occasion, when the matter was under adjudication before lordship, the lordship particularly put a question to me to be answered. That question is, what is the upper age limit which was prevalent at the time of making application of the petitioner? To that effect, to answer to lordship's query, I have filed an affidavit today, which may kindly be taken to record. Your lordship may kindly peruse the same. And in this affidavit, I have referred to the advertisement which was made by the OPSC under Annex 1, pursuant to which I made application seeking my consideration for appointment for Orissa Administrative Service. And the subsequent advertisement, which is made in the year 2022, and in terms of which I have also applied. And in the second one, the upper age limit has been fixed up to 38. So in the previous advertisement, in terms of which I have applied, upper age limit, I was within the upper age limit, and accordingly I had applied. In subsequent period, I qualified in the preliminary test, or written test, and passed, and also appeared the viability test. Whereafter, after result was published, I came to know that my elimination has been made only due to erroneous evaluation of my 3 papers. That is the public administration paper 1, public administration paper 2, and essay. And your lordship may kindly see the cutoff mark under your category was 1145, and I had secured 1097. I fell short of, I was running short of only 48 mark. Because of erroneous evaluation of my 3 answer papers, under Annex 1, I have enclosed after obtaining the same Right to Information Act. Those answer papers clearly show that.
No, 1 minute. In page 84, what is stated is that you made that statement.
My lord,
Come to page 84, sir.
84 of my appeal. Yes, my lord. Because that is the order against which I have filed this writ of appeal, my lord.
So just read para 2, sir.
My lord, my respectful submission that when the matter was taken off, the court, the honorable courts, on the basis of OPSA advocate submission that the case has
Not
become
OPSC.
infructuous.
No.
No.
That's why I'm asking to read
Yes,
para 2.
yes, Lawrence Counsel for Petition states that the writ petition has become infructuous.
You were the counsel.
No, I was not the lawyer. I was not the lawyer, but I have made consultation with the lawyer who was arguing the case, and that
Then you should
at the
file a review,
very
sir.
proceeding was
File a review. Then you file.
you know, that very proceeding.
You give this affidavit back. Give this affidavit back. You say counsel for the petitioner today maintains that although he was not counsel for the appellant, when the matter was heard, when the writ petition was heard by the learned single judge, after consulting with the said counsel, it appears that the said counsel did not make the statement which has been recorded in the impugned order. Paragraph. Counsel for the appellant seeks leave to withdraw the present appeal with liberty to file a review petition before the learned single judge to raise the above contention. Disposed of is withdrawn with liberty is paid for.
Item number 4. Item 4.
Private appeal. Private appeal.
None appears dismissed or not.
Item number 5.
In this case, item 5, my lord. This case, I beg to pray for 2 weeks' time. This is my personal matter. I want to engage some other lawyer.
All right. At the request
Item
of counsel,
5,
for
my
the
lord.
appellant, list on 1st August. All right.
Item number 6.
May I please, Your Lordship? The impugned order is under 15B of the OSS Act. And the order or impugned order is at Annexure 1. Your Lordship has find at page 12 of the order. It has not been entertained at all and directed for to approach the common law forum. And Your Lordship has entertained some of the 15B applications.
All right. Came out.
Item number 6. Sorry, item 7.
7 may be taken up along with item 70, Your Lordship.
All right.
Item number 8. Item number 8.
My lord, this is a PIL matter regarding shifting of RI office from Rajgarh Prokori Panchayat to Balimed Panchayat in the district of Bhadrak. So there is a RI office since 1965 in the Rajgarh Prokori Panchayat.
Come to Annexure 3.
Sir,
Come to Annexure 3.
yes, sir. Yes, sir. That's a representation of the villagers petitioner along with the other villagers of the Rajgarh Prokori
Where is
Panchayat.
the proof of submission of that representation?
There is a postal registration receipt, madam.
Where?
It's, it's,
The petitioner seeks leave to withdraw the present petition with ability to make a fresh representation to the authority.
sir.
And after following up on such representation, to seek appropriate representation. Disposed of is withdrawn, liberty is.
Item number 9.
My lord, 9, 10 and 11, my lord, same Alok Mishra case, my lord. Lordship have kept similar matters to 24th of 8, my lord, 24
August.
August, my lord.
Item number 12.
Well, at item number 12, Your Lordship on 16th March 2023 issued notice. The noting as per given by the office is that the postal tracking has not come, neither AD has
No,
returned.
but tracking report says it's confirmed.
It is confirmed.
Alok Mishra case.
None has appeared for the contesting respondent, who was the writ petitioner before the Honorable Single Judge. My lord, 2 writ appeals have been filed because originally, my lord, the judgment was passed without making me parties, though I was a party in the entire proceeding in the court below. I filed a review. The review, Your Lordship, will take up WA 112 or 20. When I pointed out before the Honorable Single Judge, the Honorable Single Judge stated, considering the submissions of the learned counsel for the
All right.
petitioner,
You say the none appears for the respondents despite opposite part, sir, respondents despite delivery of notice. Respondent numbers 1. Yeah, respondent number 1, who is a contesting respondent despite delivery of notice. Paragraph. The present appeal is directed against an order dated 25th July 2019 passed by the learned single judge in review petition number 81 of 2018 filed by the present appellants, seeking review of an order dated
3/11/16, man.
3/11/2013.
My lord, 16, my lord.
Okay.
Your lordship can see at
Disposing
page
of
9.
OJC number 2229 of 2000. That writ petition had been filed by respondent number 1, challenging the order of the Commissioner Consolidation Cuttack in Consolidation Revision case number 659 of 1995, which had in fact been allowed, which had been allowed by the said order in favor of the present appellant. Full stop. Paragraph, it is pointed out that during the pendency of the aforementioned OJC case, opposite party number 8 in the writ petition, Srimati Durga De, died on 19 June 2013. Full stop. This fact was not brought to the notice of the learned single judge. Full stop. Further, opposite party number 11 was shown as single quotes Ram Chandra Patra, when in fact it should have been single quotes Vijay Patra. Full stop. This too was not brought to the notice of the learned single judge. Full stop. In view of the wrong name mentioned, the present appellant did not receive any notice. Further, the writ petition was bad for non-joined of necessary parties. Paragraph. Despite all these facts being brought to the notice of the learned single judge in the review petition, he has rejected it, stating that the original judgment was passed with the materials available therein, unquote, and that if there is a question of the judgment applying to single quotes non-parties, open quotation, the same shall be decided in appropriate proceeding at appropriate stage. Full stop, unquote. Paragraph. With the judgment passed by the learned judge, single judge in OJC number 2229 of 2000 on 3rd November 2016 being adverse to the present appellants, there was no other appropriate proceeding in which all these pleas could have been urged. Paragraph. For the aforementioned reasons, this court sets aside the order dated 25th July 2019 passed by the learned single judge and allows review petition number 81 of 2018 preferred before the said court by the present appellants. As a result, the order dated 3rd November 2016 in OJC number 2229 of 2000 will stand recalled. And the said OJC number 2229 of 2000 would be restored to the file of the learned single judge. We'll stop. The said writ petition now be listed in the roster bench of the learned single judge on 7th August 2023. Paragraph. The learned single judge is requested to proceed only after notice to the petitioner who has chosen, writ petitioner who has chosen not to participate in the present proceedings despite service of notice.
Gratefully.
The writ appeal is disposed of in the courts. What is that second one?
For that second one was challenging the review. One was challenging the review, one was challenging the main order.
All right. W8 110 of 2020, you say it is disposed of in terms of the order passed today in WA 112 of 22. In the same terms. Right.
Item number 13.
May I please, Lord? Lordship, the impugn order is at page 134, my lord. Lordship, kindly see this 5 lines on the top, my lord. The learned single judge, my lord, with due respect, my lord, accepted that they were ad hoc employees and they have accepted the conditions of the advertisement, and then thereafter they participated. But at the same time, my lord, directed that since the similar matter has been disposed of and writ appeal is pending, they shall continue till disposal of the writ appeal. The similar order, Lordship, will get it at page 131, my lord. That is WPC 11408 2020, my lord.
No. So this is a batch of matters, or
Yes, batch of matters, my
when
lord.
are they coming up?
My lord, writ appeal 234 of 2020. Yes, Lordship, kindly see. Take care about it. No. 234 2020. This has been, my lord, referred to a third judge, my lord, for. Yes.
It's still pending.
My lord, pending. And the learned single judge, my lord, the third judge, my lord, has adjourned the matter. I have also got a printout of that.
Okay. The present writ appeal is adjourned awaiting the judgment in WA 261 of 2020, which stated to be pending before a third learned judge of this court. After there was a difference of opinion among the judges constituting the division bench which heard the matter. Right.
Item number 14.
14, my lord, also same, my lord, Alok Mishra case, 24-8, my lord. Here also a contempt application is pending, my lord.
All right.
This is similar to 9, 10, and 11.
All right. Same order as 19.
Item number 15.
Item 15, as per my submission, it is practically infructuous, Your Lordship, because Your Lordship may kindly see the prayer. We had approached the order under challenge. We had approached this honorable court for implementation of an interim order of the tribunal, and that out for undergoing training. But in the meantime, the petitions have already, the opposite parties have already got promotion.
Learned brother just informed me about that the respondents have got the relief, but I'll just verify, Lordship, may call it someday next week, my lord.
Why?
Because he has not produced.
Yes, I am giving.
Now producing.
Lordship, then record is.
Make a record of it. Yeah. Record that. What are the connected writ petitions?
Connected writ application also, we had challenged the order of the learned tribunal. They have also got the relief.
All right. Counsel, the respondent has produced before the court order dated 30th June 2021, issued by the Orissa Police State Headquarters, Cuttack, granting the relief which was allowed to the respondents by the impugned order of the learned single judge. In that view of the matter, the present writ appeal has become infructuous and is disposed of as such. The connected writ petitions are also disposed of likewise.
Item number 16.
Item 16 may permitted to withdraw with liberty.
Identical order I'm giving.
File review application.
Permission to file review. Same.
Item number 17.
I mean, please, Your Lordship, I mean BC mail.
Yes.
I mean BC mail. The order of the learning single judge annexure 2 is under challenge. But fact remains, my lord, the engagement of the persons, those who were engaged by the government
has been superseded.
Now in the meantime, their tenure has over. Now new set of engagement has been given. Petition may be liberty to withdraw, approach the honorable court if the phrase cause of
You
action.
say due to subsequent developments, the present writ appeal has been rendered infructuous and is disposed of as such.
The liberty, my lord, the new notification has been given. With the liberty to
What liberty, sir? Nobody is preventing you. Yes.
Item number 18.
Item 18 में 30th August rehabilitation.
All right.
Item number 19.
19 certified 8th May.
Item number 20.
20 में 14th September.
Yes.
20, my lord, I pray, my lord, of course, there is a finding that the Learned Single Judge has said that the counter has been filed, but in fact, they have taken a point in the appeal that no counter has been filed. May I pray, my lord, may remit it back for reconsideration, setting aside the matter. So that
On the short ground that the impugned order was passed on the very first day of hearing of the writ petition. Without an opportunity to the present appellants.
This is not the first day, this was not first day.
no, not first day, but you have taken a point in the writ appeal that
No counter.
counter has not been filed, but it's not filed before the tribunal or before the.
No, but it's order number 2 only.
This is my transfer matter from tribunal.
After admission, it has been transferred to High Court. High Court has passed this.
So that is order number 2.
No, which?
Sorry, I can go.
Oh,
The High Court order number 2. So they are mentioning it here order number 2.
887. Acha, acha. Where is the counter?
No counter.
No counter has been filed in fact.
Oh,
Because they have filed an application seeking for some time to file counter, but perhaps that has been taken as a counter. But in fact, that no counter has been filed. I have also checked.
but it says in the counter affidavit file, come to page 30.
Yes, yes, my lord, as Honorable Single Judge has observed that in fact counter has not been filed.
Oh,
No counter was filed, but in other, what has happened, well, it has been covered to other cases.
Other cases, taking into consideration Narusubodhan case, my lord, disposed of large number.
That has been
But in this case, the counter has
copy
been.
paste of
order passed by the learned single judge. Allowing writ petition civil bracket OAC number 2294 of 2017. Reference has been made to open quotation the counter affidavit filed by opposite parties, unquote, when in fact admittedly no counter affidavit had been filed by the appellant. Full stop. Paragraph. Consequently, there was no occasion for the learned single judge to have discussed any of the averments of the appellant in such a non-existent counter affidavit. Paragraph. Consequently, respondent agrees that the matter can be remitted to the learned single judge for fresh adjudication in view of the above circumstances. Paragraph. The impugned order of the learned single judge is hereby set aside. And WPC bracket OAC number 2294 of 2017 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 9th August. The present appellant will file its para-wise reply to the writ petition not later than 31st July 2023. And the respondent writ petitioner shall file his rejoinder thereto, if any, on or before 9th August 2023. No time will be granted to either party for that case, for the above purposes. Paragraph. The learned single judge is requested to proceed with the hearing of the writ petition on merits and dispose it of as expeditiously as possible. The writ appeal is disposed of.
Item number 21.
21 and 22, my lord, 8th of May, Sattapeda.
Order.
But on 22, there's a contempt application, it's tagged up.
Yeah.
3836.
Lord, come up.
Like,
Item 23. Item number 23.
None appears dismissed.
Item number 24. In 24, my lord, the order filed in a contempt petition has been challenged.
That can't be a writ appeal, sir.
But
It can't be a writ appeal.
in the case of that judgment of the Honorable Appeals Court, that in the case of Midnapur, your lordship has entertained some cases that I can give that judgment tomorrow.
Or it counsel for the appellant.
And
Seeks
here,
leave to
in fact, we have implemented the order under the threat of that contempt. But only point that some other cases that will be governed by this, for that we are pressing this matter. Your lordship may call this matter tomorrow. I will give that judgment. My lords also relying that judgment of Midnapur case in a contempt petition, writ appeal.
How can it be, sir? The challenge is writ appeal is to an order passed by a single judge on 17th August 2021 in contempt case number 3985/2021. Stop. When asked about the maintainability of the appeal, counsel for the appellant seeks time to produce judgments. Stop. That is request list on 31st of July.
Item number 25. Twenty-five.
25 में शर्त पड़ेगा 8th में
Item number 26.
26 for DLR regulation, 25th of September.
24th September.
Madam,
Right.
25th.
25th September.
Item number 27.
at 27 वाला शर्त पड़ेगा 8th में
Item number 28.
28 minutes writ petition was for regularization of the service after completion of 30 years of service. That was dismissed minutes because the council minutes, the petitioner could not appear through the council and thereafter filed a CMAPL and this was rejected. I pray minutes counter and everything is been filed in the meanwhile, of course. Minutes may be hard on merit minutes. It's seriously prejudicing the petitioner minutes because they completed 30 years of service.
How many years delay? How many days delay?
Minutes.
Was there a delay in filing CMAPL?
No, there is no.
All right. This appeal is directed against the order dated 14 February 2022, passed by a single judge, dismissing CMAPL number 306 of 2021, by which the appellant was seeking recall of an earlier order dated 14 July 2021, passed by the single judge dismissing WPC bracket OAC number 658 of 2000 on account of non-appearance of counsel for the appellant. Paragraph. It was sought to be explained by the appellant before the learned single judge that the brief had been transferred from the previous counsel, and the appellant was therefore unaware of the listing and hearing of the case. Paragraph. It appears that the same counsel from whom the brief was purportedly transferred subsequently filed the same CMAPL. Full stop. Considering that this is the challenge in the writ petition in the petition was to the termination order.
Yes.
What was challenged?
Regularization.
Was seeking regularization of a person who has been in service for more than 30 years.
30 years.
The court is of the view that a more liberal view ought to have been taken of the explanation offered by the appellant for non-appearance before the learned single judge on 14 July 2021. Paragraph. For the aforementioned reasons, the impugned order dated 14 February 2022 is set aside, and CMAPL number 306 of 2021 will be treated as having been allowed. Full stop. As a result, the order dated 14 July 2021. In WPC bracket OAC number 658 of 2000 will stand recalled, and the said writ petition will be listed before the learned single judge in the roster bench on 21st August 2023. This reply and all has been filed in that.
All right.
Since
Counter
pleadings
and
are
rejoinder have been filed. Of course,
Right.
after dismissal, what have been filed?
All right. Since the pleadings in the main writ petition are already stated to be complete, the learned single judge will proceed with the hearing of the petition on writs on that day, with neither party seeking any adjournment, and endeavor to dispose it off as expeditiously as possible. Writ appeal is disposed of in the above terms.
Item number 29.
29 Miller, kindly adjourn some short adjournment. My senior will argue, and today is some personal difficulty, so that short adjournment. I pray for only short
The
adjournment.
same thing happened last time, madam.
No, Miller, today, and I will file an affidavit by through relevant
Just see the
document.
order, just see the order of 24th March.
I will file an affidavit. So relevant document will required for that. So I will file an affidavit by through.
It's all right. Let's see what the matter is about.
Only short adjournment, Miller. Next week on 10th.
Let's see what the matter is about.
Yes, Miller.
Yes, there's no document produced to justify the recommendation to be appointed as principal. Who's for the respondent? Notice is not gone in this.
In this case, I have to take instruction. I have seen
Ah.
his pleadings.
All right. The counsel for the appellant. No, Annexure 3 to the appeal is a copy of an order dated 20. No, as part of the Annexure 2 to the present appeal is a document dated 20th October 2018, issued by the Directorate of Higher Education of Orissa, granting the highest scale of pay to three teachers similarly situated as the stated to be similarly situated as the present appellant. Who have been granted the highest scale of pay. Counsel for the state needs time for instructions. List on 1st August.
Item number 30. Item 30.
May I please, Your Lordship? Lord, my candidature for the post of Shiksha Sahayaka was rejected, cancelled. At the stage of selection, Your Lordship may kindly turn to page 53, Milan, indicating that the rejected due to invalid employment registration card issued after 6/4/2015, Milan. That page 53, Your Lordship may kindly turn. My serial number is 17, Milan. And that was rejected only on the ground that valid registration certificate I have not produced. When I challenged that order before this honorable court, they have filed their counter justifying their stand that she has not submitted the valid registration certificate. Subsequently, they have also filed the affidavit justifying their stand. But only at the time of argument, they have not supported their stand. Rather, they have taken another stand because she was eligible by that point of time to make the application, but she did not make. Subsequently, she had made the application. But what happened? That applications were invited in 2014. There, the age limit was 21 to 32 for the Shiksha Sahayaka. Selection was made. After the selection, that was challenged before the Learned Tribunal. Learned Tribunal set aside that selection, which was confirmed by this honorable court, and there it was directed instead of 32, 42 is to be the age limit. There, another notification was issued indicating that the person, those who have been aged but at the time of application, they can make the application, my lord. I made the application. My application was scrutinized. Your lordship may kindly turn to page 45. At the page 45, my lord.
Yes.
Serial number 12, that clause, serial number 12, employment registration number such and such, your lordship may kindly see. Towards the right corner, my lord.
Yes.
Your lordship, correct. I have indicated in my application. Then your lordship may kindly turn to my lord, page 52. After scrutiny, when the eligible list, I was called upon to submit my original documents. Your lordship may kindly see serial number 3, page 52. Employment exchange registration card, yes, they have indicated, my lord. I have submitted that. But they have rejected, indicating that valid registration certificate issued prior to 6/4/2015 has not been submitted. That was not there in the advertisement, in subsequent advertisement also.
All right. You say notice returnable. 22nd August.
Item 31.
Lord sir. Extra copy on the state I will serve. Let it be next week.
What's the matter about?
Lord sir, the order of the learned single judge is under challenge. Lord sir, matter relating to appointment of Anganwadi worker. Lord, the advertisement was that the person's Lord's qualification is immaculate, but the basic thing is that the candidate must be a resident of the Anganwadi area. If the candidate having matriculation is not available within that area, center area, then the candidate with the class 8 qualification can be allowed. Plus the appellant, plus the challenge, the selection of respondent number 4, that she does not belong to that particular area. Accordingly, the respondent, there was a provision of inviting objection. That objection was invited. But however, the selection was made in favor of opinion number 4, respondent 4. But that was challenged before the ADM being the appellate authority. But the appellate authority passed the order. Lordship kindly see. ADM's order is page 34.
Yes. 31.
Page 33 is the finding. Lord, that is the area survey list prepared and submitted by the Anganwadi worker of Udayaganj, Patna has not been authenticated by the selector lady supervisor and the CDPO Bhograi. It has been prepared on pick and choose, which was not a conformity with the service area mentioned in the advertisement of the CDPO Bhograi in respect of Gola Bogoda Mini Anganwadi Center. It is evident that dwelling house of respondent 1 is not situated. Respondent number 1 is respondent 4 here, not situated within the service area of Gola Bogoda Mini Anganwadi Center. And the selection and engagement of respondent 4 is wrong and beyond the government guidelines, which needs to be quashed at the ends of justice. Then, Lord, that was challenged before this on writ application. Now, writ application, this they say that they have, Lord, respondent 4 said that she possesses the matriculation qualification. She belongs to that center area, and the Lord single judge allowed the writ application. Lordship, kindly see the finding. Finding, Lord's particular aspect, Lordship, kindly 118.
Yes.
Page 18, after fourth line from top.
Yes.
The CDPO has accepted such report.
Yes.
And has also referred to the same in his parabise comments submitted before the ADM in the appeal, as also in the counter affidavit filed for this annual court. The CDPO was the selection authority, and she also filed the parabise comment and counter also in the before the court of ADM. The ADM has held the same to be not authenticate only on the ground that it does not bear the signature of a lady supervisor. And the learned single judge said this is a hyper technical ground. Plus, another aspect, his lordship said, your lordship kindly see page 120. The residential certificate issued by the Tahsildar should be entertained. Even otherwise, ADM could have directed the authorities to conduct an inquiry to determine the issue once and for all. This being his Lord's opinion, he should not have allowed the writ application. He should have referred the matter, Lord's remanded the matter to the
ADM.
Yes, to verify and to reconsider the issue.
On the issue whether you are there for opposite party.
And for the respondent 4.
survey report of the Sangita Kundu Maila, which was conducted survey report and submitted before the authority, it is found that the house of the present respondent number 4 Maila coming under the 103 to 113 and the house number is 110. They are saying that it is not coming under the only on the basis of a voter list, which is not accepted, my lord. The survey report provides, my lord, is as per the advertisement, it is clearly provides, my lord, the house belongs to 103 to 113. So present respondent for house is coming under 110, my lord. That has been taken into consideration under answer 5, the survey report submitted by the Sangita Kundu. And the person who has challenged, my lord, he will have no right qualification. Another person is Anjali Das, who was a matriculate. At that time, 2 persons were coming into selection. Anjali Das scored 39%, the present respondent for 72%. Accordingly, the present respondent is selected. After 3 months, she has preferred appeal, my lord, after beyond the limitation. And she also not objected before the CTPO that my house is not coming under the stipulation, my lord. After 3 months, he has preferred the appeal. Thereafter, appeal has been taken, and without any basis, my lord, it is said that he can choose with. Despite the inquiry report is submitted, survey report, and she is not coming under the consideration, my lord. Zone of consideration. Anjali Das has not preferred in the appeal.
Yes.
So everything has been clarified in the judgment, my lord, by the Honorable Single Judge. And when he became unsuccessful, he has preferred the appeal.
Yes, please.
Lords, other two aspects, Lords, what the with regard to that residential certificate issued by the Tahsildar. Lords, the finding I had drawn your Lordship's kind attention with regard to that survey report. That is the only basis for which the respondent's selection was quashed. Now, survey report has been prepared without furnishing the house number, without furnishing the serial number, etc. Therefore, the fact-finding authority, the ADM, came to the conclusion that the report being on the basis of pick and choose basis, that was discarded and the selection was quashed. Lords, if your Lordship conceive that survey report is valid, that cannot be accepted for the sake of this present case, because the appellate authority, the ADM, is the authority of the entire selection. And he came to conclusion that survey report prepared not in accordance with the procedure prescribed. If the survey report is not in accordance with the prescribed procedure, that has to go, my lords. And if at all the learned single judge comes to a conclusion that the ADM should have remanded the matter to the lower authority sub-collector to make further inquiry and to pass order, there is nothing wrong. Lords, other two judgments, Lords, I have also cited before the learned single judge that I have also enclosed, and including one writ appeal where the residence certificate basing on which the selection was made, that was quashed. No, that was a temporary certificate that cannot be accepted. And that your Lordship kindly see page
So today,
88.
who's working there? You're working?
My lord.
Who's working as Anganwadi?
I am a working man. Respondent for me.
He sees
Last 7 years
because
I
of
am working.
For how many years now?
7 years.
I was before Lordship as well as before the ADM. There is no mistake for me.
All right. The present appeal is directed against an order dated 6 September 2022 passed by the learned single judge, allowing repetition civil 26519 of 2017, filed by respondent number 4. Thereby setting aside an order dated 21st November 2017, passed by the learned Additional District Magistrate Baleshwar, in allowing Anganwadi Appeal number 5 of 2017, filed by the present appellant, who had questioned the appointment of respondent 4 as Anganwadi worker bracket AWW at the Golabagada mini Anganwadi center under the ICDS project, Bokra. Right. The challenge to the appointment of the respondent before was on the ground that she was not a resident of the service area as advertised by the CDPO Bogra for the concerned AWC. In the order dated 21st November 2017, while allowing the appeal of the present appellant, the ADM noted that the dwelling house of respondent before was not situated within the service area of the concerned AWC, and that the area survey list submitted by the AWW of Udayganj Patina had not been authenticated by the sector lady supervisor and the CDPO Bogra. According to the ADM, it had been prepared on pick and choose. Right. The learned single judge has in the impugned order referred to the fact that in the survey report, the house of respondent before was at serial number 110, which was the house of her father-in-law, in which she resided along with her husband. The survey report prepared by the AWW of Udayganj Patna also substantiated this plea. The CDPO also accepted that report. So only because it did not bear a signature of the lady supervisor, the ADM held the said document not to be authentic. The learned single judge further noted that apart from the survey report, a residence certificate was also issued by the Tahsildar, which states that the respondent before was ordinarily residing at Udayganj Patna. The learned single judge was therefore prepared to accept the above plea of respondent before about her fulfilling the residence requirement. It was observed that if the ADM had any doubt in regard to the authenticity of the report, he could have relied on the report of the Tahsildar or asked the authorities to conduct an inquiry. Paragraph. Counsel, the appellate urged that since the learned single judge observed that the ADM ought to have directed the authorities to conduct an inquiry, so that direction ought to have been issued by the learned single judge, instead of setting aside the decision of the ADM, allowing the appeal filed by the present appellant. Paragraph. The court is unable to agree with the above submission. Full stop. There was enough material on record before the learned single judge to substantiate the plea of respondent before that she fulfilled the residence requirement. Full stop. That being the only ground in which the ADM sought to cancel her appointment, the inevitable result was the reversal of the ADM's order. Paragraph. Having heard learned counsel of the parties, the court is not satisfied that any ground has been made out for interference with the impugned order of the learned single judge. The appeal is dismissed.
Item number 32.
My lords, the appellants are all accountants working. They were working in Kasturba Gandhi Balika Vidyalaya. My lord, is government decided that all the male people are to be replaced from this institution. Those who are working as part-time teacher, peon, head cook, and watchman, they approached in a number of original applications before the Honorable Court, challenging the order passed by the London Tribunal. Your Lordship passed order in Annexure 7, page 42, rejecting their claim. So for the accountants, the reason is they had direct access with the hostel and where the students are residing. The accountants, my lords, those who are only attached to the school and they're doing the accounts work, they filed number of original applications and that came on transfer. Annexure 9 at page 59 is the order passed by the Honorable Single Judge. The order passed by the Honorable Single Judge earlier and which was upheld by the Honorable Division Bench in the subsequent order was relied on by the Honorable Single Judge. And the Honorable Single Judge rejected the claim, stating that that order guides this case. In fact, my lord, I feel there is not much merit in the case.
That's fair enough. All right. The present appeal is directed against an order dated 18 July 2022, passed by the Honorable Single Judge, dismissing writ petition civil OAC number 2193 of 2014. And a batch of cases. whereby the plea of the present appellants, who are accountants working in the Kasturba Gandhi Balika Vidyalayas, who are praying for the regularization of the services. It appears that another set of employees, namely part-time teachers, cooks, and watchmen, who were engaged in the same institutions, had earlier filed a separated petition before the learned single judge. That is WP Civil 25385 of 2014, which came to be dismissed on 21st December 2017. So the writ appeal against that judgment was also dismissed with the division bench on 6 March 2019 in WA number 159 of 2018. So, paragraph, the learned single judge has chosen to follow the aforementioned orders of the coordinate bench in rejecting the plea of the present appellants. Although it was sought to be urged by Mr. Rathar, learned senior counsel to the appellants, that the case of the appellant accountant stood on a different footing from the other class of employees. The fact remains that their engagement was only on casual basis. And created no vested right for regularization. One of the pleas urged in the petition you have a copy of that order in 21/12/2017. It's here. Right. One of the issues discussed in the earlier judgment dated 21st December 2017, the learned single judge, in writ petition civil number 25385 of 2014 and batch, was the legal validity of the decision dated 17th July 2014 of the state project director to remove male staff engaged in the KGBEs. Which comprised 750, which was 750 in number with boarding facilities at elementary level, open quotation, for girls belonging predominantly to the SC, ST, OBC and minorities in difficult areas, unquote. It was noted that the schools might have to be set up in areas with concentration of tribal population with low female literacy. With a large number of girls out of school. To stop, the objective was to ensure access and quality education to the girls of the disadvantaged groups. Full stop. It was accordingly decided that preferably only female staff should be deputed. As concern was set up about male teachers and accountants, open quotation, having access to living quarters of girls, unquote. In that view of the matter, the rationale regarding disengagement of male staff, which applied to other posts of male cooks, drivers, etc., would equally apply to the accountants, like the present appellants. Stop. With the said decision already having been affirmed by the learned single judge and the said judgment having been further confirmed by the division bench, but the case of the present appellants could not be placed on a different footing, as urged. Paragraph. Having heard Mr. Rathal and a senior counsel for the appellants, the court is unable to be persuaded that the learned single judge has, in the impugned judgment, committed any error that calls for interference. Full stop. Accordingly, the present appeal is dismissed.
Item number 33.
May it please.
24 July.
Seven days delay was there. I have filed an application already.
No, is it connected with those other matters?
No, it's not connected. Here it's a matter relating to the respondent number 3 claimed pension for the past services rendered by him. He was in the government service and thereafter he joined the appellant's service. He was absorbed in 1981. In 93, he retired. After retirement, he pursued the pension with regard to the government service with the government and also filed OA, Administrative Tribunal. He has approached and those things. And when those matters are pending, in 2011, he made a representation to the board saying that he is entitled to past services also. Therefore, pension should be recalculated. He was being paid pension and other things. And then it was not paid, therefore he approached this honorable court. Here a stand was taken that under Rule 44 of the Odisha pension rules, if a government servant wants to absorb in an autonomous body, he has to make an option. The option should be given within 1 year. He has not taken that option. Therefore, he is not entitled to get that pension because the entire pensionary benefit.
Option for what?
Option to come under the autonomous body. I have extracted that rule also. You will also kindly see at page.
No, option to come under the autonomous body.
Under the autonomous body.
No, but does he have an option to not continue therein? Does he have a choice about not continuing with you?
No, not continuing in service, to come under the pension scheme. Pension, you will also kindly see, I have extracted that clause at page 50. Page 50, a government servant with a contributory provident fund benefit on permanent absorption in an autonomous body will have the option either to receive contributory provident fund benefit which have accrued to him from the government and start his service afresh in that body, or choose to count service rendered in the government as qualifying service per pension in the autonomous body by foregoing the government share in contributory provident fund and contributions with interest which will be paid to the concerned autonomous body by the concerned government department. The option shall be exercised within 1 year from the date of such absorption. If no option is exercised within the stipulated period, the employee shall be deemed to have opted to receive the contributory provident fund benefit. The options once exercised shall be final. This is for coming under the so far as the service rendered during the government service, he will be entitled from them. If he makes an option, then that entire fund deposited by him in the government will be sent to this autonomous body and they will pay it. This question was raised specifically, and Honorable Single Judge, although he has rendered a long judgment, did not answer this question. That is why I am before your lordship.
To come to para 20. 22.
This clause was extracted. This is my counter.
No. Para 22, sir, the judgment. Page 56.
Judgment. Yes, madam.
Just read it.
It is unambiguously clear that the time of the pension by the time the petitioner joined board services, provisions for pension in respect of board services was not available. Hence, the initial period of board services spent by the petitioner from 23-1976 to 31-7-81 was treated as deputation from government service as per the office order dated so-and-so, issued by the opposite part number 3. The petitioner was absorbed as a permanent employee of the board. Subsequently, by virtue of the Board of Secondary Education Amendment Regulations 1997, the board employees who entitled to pension with retrospect to application from 1/1 to 1982. With regard to the said, the Regulation 22 stipulates the period of qualifying service for the purpose of pension calculation in respect of employees of the board. It is not in dispute that under the terms and conditions, the Board of Secondary Education remitted its pension contribution for the petitioner till 31-7-81 on the basis of the calculation of rates of leave salary and pension contribution in respect of employees for deputation under foreign service. However, it all get merged and redundant after incorporation of the provision of the pension by the Board of Secondary Education on introduction of the Board of Secondary Education Amendment Regulation 1997. Therefore, the petitioner has rightly contended that petitioner having retired from service on reaching the age of superannuation effective from 31/8/93, he became legitimately entitled to full pension from the board by taking into account the entire service period, including the past service of so-and-so years in the government and 5 years in the board on deputation, besides
which is strictly construed under Regulation 22 of the 1997 Amendment Regulations.
The amendment regulation, my lord, that says that in addition to the pension rules will apply, but pension scheme was introduced by the board. Board didn't have the pension scheme earlier.
That's right.
In 97, they have introduced this and asked for the option of all the employees existing.
No, but it was transferred. That whole thing, pension contribution, the Board of Secretary remitted its pension contribution till 31/7/81.
No, that is till 81, my lord. He is claiming the past services.
Yes.
Prior to that.
Correct.
Prior to that, he was in the government and he was pursuing. He was pursuing with the government, and he has also filed OA. In 93, he retired. In 2011, when the OA is pending before the administrative tribunal, he approached saying that we should pay it.
Yes.
But he has not opted. He has not opted as per that Rule 44, and therefore that amount has not come to the board.
Just come to para 25.
Admittedly, board is held to have discriminated. This is wrong, madam. Discriminated against the petitioner, considering the fact that several similarly placed individuals have already been granted respite by this court. Such a discrimination, this is not correct, my lord. I will point out, my lord, your lordships will see at page 25 of the brief. Page 25. The person who was given, this was by consent order. Mr. A.K. Misro, Leonard Senior Counsel appearing for the Board of Secondary Education, submits that the services rendered by the petitioner under municipality shall also be calculated and the entire pension will be released by the Board of Secondary Education. The concession of the Board of Secondary Education may not be treated as a precedent. Is under that particular case, without treating it as a precedent, it was paid because of the concession given by the council.
Right. Council for the appellant contends that the observation in the impugned judgment of the single judge that other similarly placed persons were also granted the option of getting pension under the old pension scheme is incorrect. Stop. In one such case, it was done as a one-time measure without creating a precedent. Stop. In the present case, according to the appellant, the respondent number 3 did not exercise an option. And therefore, there was no obligation on the appellant board to count his past service in the government for the purposes of pension. Paragraph is a notice returnable. Second August. Is there a contempt petition? Is there any contempt petition filed? You just say notice on the stays. 3395, this case. All right.
Item number 34.
You just say counsel for the appellant, right in the beginning, you say states that he's already filed an application for condonation of delay. Is that right? Saying that he's already filed. Mr. Rao, you are saying you already filed the delay application.
Yes.
When did you file it?
I filed it on 1st May.
All right, on first.
IA.
All right.
IA 2284 of 23.
IA 2284.
84.
You put notice on that as well. All right.
Item 34.
In item 34, Department of School and Mass Education is the opposite party. And the counsel who was conducting this case has recently been appointed as a legal retainer for Department of School and Mass Education.
Item 30 for similar material also is fixed to 11th May.
All right, list on 11th. All right.
Item 35.
35 mal works are 14th September.
14th September.
Item number 36.
None appears.
Item number 37.
Item 37 and 43. These are two read appeals and batch of read appeals are there. A batch it comes out of the batch of read petitions. I'll prepare a short date chart and with all the documents, the Lordship can call this matter next week any day. 37 and 43.
All right.
In fact, there are about
10, 15, 20 matters.
35 matters. Writ application which have been disposed of by a common judgment, but facts a little bit different and counter also filed. My learned friend has filed these two writ appeal. I think he has not filed the other.
Others are prepared, not filed.
Then
we are
in that
taking
event,
steps. So your Lordship may call this matter next week.
All right. It is stated that
then why
apart
not
from the
after
present
that
two appeals,
application?
there are other writ appeals in the pipeline directed against the same impugned common judgment of the done single judge in the batch of writ petitions. Paragraph. Mr. Puntia Learned AG states that he will prepare a short written note of submissions for the assistance of the court. List on.
No contempt application has been filed till date. If your Lordship can fix up immediately after vacation so that it will be better.
June.
Yes, bless.
Also 43.
Yes, both matters. Put both together.
Item 38.
38 mal works are 14th September.
14th September.
Item 39.
39 or rehabilitation 30th August.
30th August.
Item number 40.
May I please? My lord, the appellant has challenged the imposed order dated 28/11/2022, my lord, passed by the Honorable Single Judge on directing the Tahsildar to demarcate the suit land, my lord. My lord, without the Honorable Single Judge, my lord.
Sir.
My lord.
Despite two adjournments, defects have not been cured.
The certified copy not filed. Certified copy already
Despite
filed.
two adjournments. Two adjournments were granted only for this.
The certified copy, I doubt the certified copy not filed. They already filed the 2 days after the certified copy. The impugned order, my lord. The impugned order 22 already filed, my lord.
So the defect is that you did not file certified copy.
Yes.
Two adjournments were granted for you to cure that defect.
Yes, my lord.
You
Already
not cured it.
Already certified copy, the impugned order 28/11/2022 already filed, my lord. That's
when
2 days after already filed, my lord.
Just show him
The dear deputy register, my lord. The dear box, my lord. Already filed, my lord. Impugned order, my lord.
1 minute. Just show him the paperwork. Show us the certified copies. Show us the certified copy.
Not distant, my lord. 2 days after lord filed. No, they did document. Yes, my lord.
Sir, it's not a certified copy.
The certified copy
It's
be
a
already.
true copy.
No, no.
In a photocopy, it's a certificate given by the head clerk of Balipatna Tehsil.
No.
This is not a certified copy.
Yes, my lord. 2 days after the file the certified copy, my lord. Smell.
Sorry?
2 days after file the certified copy, my lord. First file the true copy, my lord. Thereafter, my lord are directed to file the certified copy. Already filed, my lord, certified copy, my lord.
Where is the certified copy? You're showing the true
Let's
copy.
kindly take 2 days after, my lord.
What is the diary number under which you filed it? Give us the diary number.
Diary number 50.
Section 40.
Let's can take on Friday, my lord.
Why have you challenged this impugned order?
Yes, the challenge the impugnator demark the suit and my lord. My lord, the matter is the sub judice of the title suit in the Law and Civil Judge Senior Division, Bhubaneswar, my lord. Without giving the notice of the present petitioner, the Honorable Single Judge passed the demarcation of the land, my lord. The disputed land, the title suit, right title, interest, and confirming the possession of the already filed, my lord. That is the which the illegal, my lord, demarcation. Let's say we can see revenue authorities notification, my lord. Once the matter is sub judice, civil court, revenue court should not give in the finding and the issue subject matter, which is matter is a decision by the civil court, my lord.
My lord, it is a fit case where he should be filing a review petition before the Honorable Single Judge. Because
No, but
without
no-
hearing him, he has the
Yeah, but no notice even has gone.
no notice and without
No.
let him file a review petition there. Because he says that I am a
Notice ought to
necessary
have
part.
gone to him. No? Now we'll have to. Now this order can be passed without notice to the writ petitioner. It is pointed out that the impugned order was passed in the very first take, ordering the Tahsildar to undertake a demarcation exercise without notice being issued to the present appellant, who was impleaded as opposite party number 5 in the writ petition. Full stop. You say notice, Mr. Mohanty accepts notice on behalf of opposite party, respondents 1 to 4. Notice will now issue to respondent number 5, the registered speed post. Tracking report will be placed on record. Till the next date of hearing, there shall be a stay of the impugned order. Then you say the right to the degree, you say counsel for the appellant maintains that he has in fact filed a certified copy of the impugned order 2 days ago. The registry will check this. All right.
Oh, bless.
Let's go on. Item 22nd August.
41.
41 with all due respect, sir, I seek 1 week time to remove defects, man. All right. You say list on 31st July. Defects be cured in the meantime. Much grateful, sir.
Item 42.
42 September 8th May.
8th May.
Item 44.
And we please your lordship. I'm on virtual mode, madam.
Yes. Limitation
Can
steps
you
not
see the
taken,
impugned
sir.
order?
No, limitation.
Limitation.
Steps not
Very
taken.
lordship, can you turn to page 39. Page 39.
Yes.
Before that, my lord, I will make 2 submissions. I was initially appointed as a class 4th employee. In the year 2009, in the year 91, I was promoted to the post of junior clerk because there is a 10% vacancy for the post of class 4 to class 3. However, my lord, in 2004-5, they decided to revert me because after completion of 15 years, they decided to revert me on the ground that my appointment was irregular or not through direct recruitment. Then, my lord, I approached the tribunal in 2005. Lordship, can you turn to page 39? Page 39, my lord. Lordship, can you look at the top. WPC number, OAC number 1590 of 2005. Lordship, got it, my lord?
But you've told the learned single judge you have no instructions.
My lord, and liberty granted me, my lord. Lordship, look at below that. Lordship will get that liberty granted to approach the authority. Then, my lord, I immediately approached. That was disposed upon 21st 12 2021, my lord. Application is 2005. Then your lordship, can you see, my lord, I approached the authority. Since no action was taken, I approached again approached the High Court. High Court said it is 2004 litigation and status quo was also granted by the tribunal. Meanwhile, I am retired. I am not getting the retirement benefits because of the pendency of this writ application and as to whether I will be reverted or not. So therefore, my pension has not been given for the last 13 years. But I'm sorry, for 10 years. And I was in 2005 approach during the cause of action. Then it was transferred to High Court.
No, but
High
there's
Court,
is there a delay in filing the present appeal?
47, my lord. Lordship can talk to page 47. The impugned order.
1 day.
Actually, 1 day is delay. All right.
Liberty was granted, then I approached the authority. No action was taken. Again, I approached the High Court. So there is no delay. Liberty granted with the High Court to approach if there is any cause of action. Immediately I approached, and within 6 months, I approached the High Court.
Yes, who's there?
Yes, ma'am.
This is the second round pursuant
Yes.
to the liberty granted.
Yes, ma'am. That I have seen that in that original application,
All
liberty
right.
was granted.
All right. You see, the challenge in the present appeal is to an order dated 10 January 2023, passed by the Lord Single Judge dismissing WP Civil number 36352 of 2022. Paragraph. The said petition was the second round of litigation. Full stop. Initially, the appellant had approached the Orissa Administrative Tribunal with an application questioning
The reversal of the petition order. Appellant.
Yeah. Questioning is reversion by orders dated 2nd August 2004 and 23rd July 2005 from the post of junior clerk to the post of attendant. Stop. The OAT had granted a status quo order. After abolition of the OAT, the case got transferred and to this court and was registered as WPC bracket OAC 1590/2005. On 21st December 2021, the said petition was disposed of by this court by the following order. Take from page 39. Paragraph. Immediately after that, the appellant made a representation on 5th September 2022 to the Commissioner cum Principal Secretary, Department of School and Mass Education, praying inter alia for regularization of his pension and for release of all his financial and retirement benefits. For which the cause of action survived. Paragraph. When this representation was not acted upon, the appellant was constrained to file the second writ petition, being WP Civil number 36352 of 2022. Praying that he should be extended all consequential service and financial benefits in the post of junior clerk. Stop. In the impugned order dated 10th January 2023, while dismissing the writ petition, aforementioned writ petition, the learned single judge has observed that since it was filed after a long lapse of 18 years, the writ petition suffers from delay in latches. Paragraph. Given the above background, where the petitioner had approached the OAT in 2005 itself, immediately after his reversion, and that writ petition after transfer to this court, and that petition after transfer to this court was disposed of by the learned single judge only on 21st December 2021, following which the appellant immediately made a representation command. It could not be said that the second petition filed by him was barred by delay and laches. Full stop. It will be recalled that the appellant had been granted leave by the learned single judge to pursue the matter if any cause of action survived. And the plea regarding his retirement benefits was certainly a cause of action that survived. Paragraph. For the aforementioned reasons, the impugned order is hereby set aside and at petition civil 36352 of 2022, or should we pass an order that you should consider the representation set aside, full stop. The petitioner's representation dated 5th September 2022, bracket Annex 19 to the writ appeal, will now be considered by the Commissioner, cum Principal Secretary, Department of School and Mass Education, and after notice to the appellant and giving him a hearing on a date to be informed to him at least 10 days in advance. A reasoned order shall be passed not later than 1st July 2023 and be communicated to the appellant within a week thereafter. Full stop. It is made clear that the court has not expressed any view in the matter. Full stop. If the appellant is agreed by the said decision for any reason, it will be open to the appellant to seek appropriate remedies in accordance with law.
Obliged.
The appeal is disposed of in the above terms.
Item 45.
Job contract period 14 September.
14 September.
Item 46.
In 36, Lordship's order 23 to
May I please, Your Lordship?
2023, their Lordship had directed me to take instruction whether they can be regularized or not against any vacant post. But I have got the instruction in course of the day, my lord. Yes, so they have taken the stand that since similarly situated persons have been regularized, their case is to be regularized. Their regularization has been recalled in the meantime. So
No,
this
that-
person-
Well,
this person- let me complete. So these persons cannot be regularized. I can file an affidavit to that effect.
All right.
My lord, may I please your lordship, my lord, I am for the opposite petition, my lord. Your lordship, when your lordship, the similar persons of the Malkanagiri district attendants were regularized in the year 2012, my lord, pursuant to the order of tribunal. When your lordship directed to take instruction, my lord, after 12 years of their regulation, the government issued a letter to the CDMO, immediately recall and cancel the order of
After 12
regulation.
years?
Yes. After 12 years, and now we have got the interim order of stay, my lord. Before
That I am
the
submitting that, my lord, that regulation has been, because what has happened, my lord, in earlier case, the direction was given to consider the representations. In fact, they are continuing under medical health unit. So they are not covered under the result.
How can you recall after 12 years? What is
So my,
this?
that they,
Totally
that they cannot, because of.
And that too
because
citing
of
your
this-
lordship's order.
No, what has
passed
happened, my
in
lord,
this
because
case.
of this regularization of only in respect of throughout the state, only in Malkanagiri district, the medical health unit, the attendants were regularized.
That
And
means
taking that plea, my lord, all other class for employees who are working under medical health unit, they claim regularization.
Anyway, you say Mr. Kunti, a learned counsel appearing AGA states that the order regularizing similarly placed attendants working under the control of the CDMO Malkanagiri was recently recalled by the government nearly 12 years after such order of regularization. Full stop. It is pointed out that the said recalling order has been now challenged in a separate writ petition which is pending before the single judge, in which an interim order of stay has been granted. Paragraph. Mr. Kuntia states that he will need to place on record by way of an affidavit all the above facts and prays for an adjournment. the affidavit be filed before the next date. List on 7th August.
My lord, only, I may be permitted only one submission. Your lordship, on the last two occasions granted to obtain instruction, only 7 days back, the last occasion your lordship granted the adjournment, it's on the very same day the facts issued citing the Balangir case, which is today's case, my lord, to recall that order. So it is a contemptuous after your lordship to obtain instruction, they have directed to cancel. And that too, my lord, I have attached, my lord, the government recently in 2013 has taken a policy decision to regularize throughout all the MHU's attendants. That is, I have enclosed to the petition, sir. Your lordship has...
Let them file the affidavit, sir. You can respond to it.
My lord. The lordship posted to...
7th August. Item 47.
Wait, please, my lord. This is a challenge to the order of learned single judge for consideration under rehabilitation assistance scheme.
30th
without notice, my lord. This is stay application, my lords. 1 to 7.
Same order.
My lords. Oh, bless.
Item 48.
48, my lord, promotion during pendency of vigilance case, my lord, 11th of May.
11.
Item 49.
49, 50 and 52, my lord, 8th of May, Satpata case.
51.
51 is...
51 works at 14th September, my lord.
14th September.
Item number 53.
53, I'm giving the similar order.
Detail.
Similar matter, take to 26th June, my lord.
Item 54.
54, vigilance case, my lord, 11th of May.
Item 55.
55, my Satpata 8th May.
56.
56 Satpata, my 8th May.
Item number 57.
57 also same, my lord.
56 is not Satpata, my lord. That is the real RS scheme, my lord.
Sir,
Appointment under RS scheme, my lord. I am for the
56,
respondent, my lord.
not Satpata, 30th August, my sorry.
56 is 30th August.
Note 57.
57, 8th of May, my lord, Satpata.
57. Item number 58.
May I please, your lordship. The lordship order on this challenge at page 33. Similar order has already been passed by your lordship, posting it 11th May.
All right. 11th.
Delay is there, my lord.
All right. Let's see. 11th May.
Okay.
Item 59.
59, my lord, Satpata, 8th of May, my lord.
All right.
Item number 60.
60.
Item 60. 60.
There is a point of limitation raised by the office. And the Honorable Single Judge dismissed the review on 17/2. I received a copy on 24/2. I discovered there is a omitted dicta observation to the opposite to the management company, respondent number here. If she chooses. So I tried to get it expunged in the IA. IA was disposed of in 11.
Anyway, 11 application, you have to explain all that, sir.
Miller.
File an application to explain such things.
Yes, I will do that. And the other defense, this is an urgent matter. Gratuity is pending for 9 years. I will remove the defects, all the defects, and file the petition within 2 days. Your lordship will take it about next Wednesday. My humble prayer, your lordship.
List on.
Lordship may decide. I will file petition within 2 days.
If it's be cured,
Item number 61.
We have to the lordship. I have given short notes in review.
The petition filed this review petition and bill has condoned the matter has had for 3 occasions. The petitioner challenged the review order dated 19th to 12 million. The findings of the honorable court is contradict each other. I am giving this date chart Miller. The present petition was opposed by 7 in the petition. And the present Manoj Kumar was the petitioner. He has challenged the final gradation list prepared by the opposed by 103 and Esther 14. And that was prepared after disposal of the objection filed by the petitioner. And that you kindly see, I can look at the judgment, para 6, page 8. There is nothing on the record to show that CDA engaged the Balasrama as a service provider to deploy his own staff employees to CDA for performing any service, nor is there is acceptable materials that the petitioner was an employee of the Balasrama. Admittedly, the petitioner was only sponsored by the Balasrama and was engaged by the CDA since 1589. Since he was sponsored by the Balasrama, his wages and the wages for similar other persons who have been sponsored by the Balasrama were being placed with the Balasrama for disbursement to them. For performing the work of dispersal of wages, the Balasrama was being paid by the CDA 5% of the amount of wages. It is also not case where the Balasrama was deducted any amount from the wages or stock remuneration of the petitioner or others in sponsored employees. The mere arrangement of the disbursement of wages for the petitioner through the Balasrama as because he was sponsored by the Balasrama would not sufficient to say that the petitioner was not DLA employee of the CDA. Rather, it is admitted case with parties that while continuing as a DLA employee, the petitioner was a direct received payment from the CDA. My submission to that extent is that kindly I have given the selection that chart. The opposed party, the read petitioner was engaged through Balasrama from 1589 to 2892. But that period has calculated for the fiction seniority. My submission is that since there is no direct relation to the master servant under the CDA, that period should not be counted. And the present petition filed the review petition, he was opposed by 7. He was directly engaged as a DLR on 1/12/1990. But where is the present, where is the read petitioner?
Where is the error was engaged? Where is the error on the face of the record?
Sir, the petitioner filed their counter along with all the documents stating that the opposed the read petitioner was sponsor candidate of the Balasrama, not direct DLA employee of the CDA. Unnecessary in that counter, the counter, all the matters are available, but that is not considered.
That's a ground for appeal, sir.
Counter file with the president or read.
That's a ground for appeal, not a ground for review, sir.
Sir, though all the matters are available before the honorable court, but that is not considered at the time for the judgment. But since the present read petitioner was a outsourcing employee, there is no question of direct master relationships. But how he is senior to the present review petitioner, and the present read petitioner is losing the 12 years seniority. And he is a qualified person, also having a LLB degree, he is entitled to get the law officers. Now he is debarred to seniority for more than 12 years. And in the meantime, what happened? Manoj Misala, who got promotion to promotion, he is retired. And getting without having his without having any requisite qualification, by getting over the authority, he has promoted from promoted to promotion, higher promotion. My son, the matters are available before the authority, before the law court, that had not considered at the time of passing the judgment.
No grounds made out for review.
So I have given all the documents and the materials available for this authority. Now the present person is losing more than 12 years seniority.
All right.
Item number 63.
63.
63.
May please also, on behalf of Mr. Bose, my lord, one passover places list.
All right.
Now the Tahsildar is in virtual mode.
All right.
If I may, please, Your Lordship, I may file the rejoinder in the court itself.
Which matter, sir?
Is
63.
Yes, the Tahsildar is present. If he is filing a rejoinder, let another date be fixed for final hearing.
My lord, last occasion, if your lordship may kindly recollect, I had pointed out in the counter affidavit that they have suppressed the fact that the civil suits are there, my lord. Your lordship may see civil suits are there, which they have not averred in the writ petition, my lord. And there is an order of status quo, and it's a contested order of status quo.
They filed an affidavit today, sir.
Yes, ma'am.
Rejoined. The rejoined has been filed today by opposite party number 4. Copy of which has been handed over to counsel for the other parties. The Tahsildar Balikuda will remain present online on the next date as well.
My lord, he will remain present on the next date. But,
online
I have filed the counter affidavit. What has happened? Let me place before your lordship. There was a eviction order, and the petitioner filed the writ petition claiming that eviction order should be implemented. But he has suppressed the fact that in the meanwhile there was a civil suit between, and there is a status quo order.
Where is your affidavit? I'm not able to find your affidavit.
My lords,
you say you have filed an affidavit.
Yes, in my affidavit that is also I have annexed.
Where is that affidavit? For opposite party number 3. All right.
I pray that his appearance may be dispensed with.
All right. You see, what's the date of the affidavit? 22nd February. All right.
It is a matter to be now contested between the petitioner and the opposite party private
need not be
respondent.
present till further orders. See list on 22nd August.
My lord, I request my learned senior may also hand over a copy of that affidavit so that I can assist you.
All right. You say an affidavit of copy of the affidavit of opposite party number 3 be handed over to counsel for the petitioner. All right.
No, 22nd.
Much obliged.
Item number 64.
May please, your lordship. Well, kindly see the last order. 2023. Well, kindly see the para 3, my lord. Learned counsel for the appellant wants to examine the said rules and make submission. Last occasion, my learned friend sought a copy before your lordship. I have gone through the entire education manual. That rules I have not found. So I pray your lordship kindly give me a copy to the learned counsel.
I will give copy of the relevant rules referred to in the order dated 23rd March 2023 be supplied by Mr. Kuntia, the learned AGA, to the counsel for the appellant. Since he is unable to locate them. Since he says he is unable to locate them. List on 28th August.
Item 65.
May I please, my lords? My lords, please, writ appeal has been preferred against the order passed by Honorable Single Judge. Your lordship will find, which is available at page 24. It starts. A relevant portion, your lordship will find at page 26. On the premises that this is covered by another order passed by the learned single judge, this order has been passed. Page 26. The directive portion is, in these circumstances, this court interfering with the order involving eviction of the petitioner in the above
only for 3 months.
Sorry,
3 months is over long ago, sir. This order was passed on 1st July 2019.
I'm conscious of that, madam.
And he was to occupy it only for 3 months. That's what it says. Just read that order.
Possibly, I couldn't express properly.
No, even I'm reading what you're saying.
Yes, my lord. But this is not covered.
Just read the 3rd paragraph.
But yes, my lord. In these circumstances, this court interfering with the order involving eviction of the petitioner in the above writ petition set aside the eviction order involved therein and directs the authorities to allow the petitioner to occupy the quarter in his occupation presently for 3 months. Your lordship is correct over there.
Well, just go on.
3 months. And in the meantime, take necessary steps for getting the new quarters in his hand fully ready within a period of 8 weeks. On availability of new quarters, it will be open to the authorities to shift the petitioner to the new housing area and allot the quarters in his possession
So what have
to the
you done?
newly joined employee. This arrangement was made and this submission was made by the government before the honorable single judge, that quarters which are coming under the 25% quota, those will be given to them. This particular petitioner doesn't come under 25% quota. That is the problem.
Where's the question? All this has worked itself out, sir. He used to be there only for 3 months.
Your lordship is correct. Much time has flown in the meantime.
The order, impugn order, was a time-bound one, under which the respondent was to be in occupation of the quarters only for 3 months, and thereafter to be allotted new quarters. Clearly, the order must have been worked out due to passage of time. Full stop. Leaving the question arising from the impugn order open for decision in some other case, the appeal is disposed of.
Item number 56.
May I please, Lordship? My Lord, Lordship, the impugn order is at page 17, Lordship. See, here the respondent had approached the honorable single judge, praying that the representation may be considered for release of family pension. The learned single judge, my Lord, directed the state government to release the pension and also directed interest to be paid along with that. Lordship, our ground is, my Lord, the respondent's husband has been dismissed from service. That fact was not brought to the notice of the honorable single judge. And in case of dismissal, they are not entitled to any benefits. Lordship, I kindly see notice was issued on the last occasion, my Lord. I think my Lord, senior is appearing.
Yesterday I have appeared on behalf of the respondent. So date may be fixed for final hearing.
Why? What is the?
As per Rule 33, he is not entitled for any pension.
Was the husband of the respondent dismissed from service?
He was convicted in a criminal case. Only about 15 grams of ganja. Some conspiracy has been made against the husband of the petitioner, and 15 grams of ganja has been recovered from his pocket when he was entered into the jail. So one proceeding has been initiated and he convicted for 6 months. Everything has been narrated in the writ application.
No. We are not on the conviction part. Was he dismissed from service?
Dismiss, I could not know.
Yes,
but because I am not
convicted in the criminal case,
and therefore
also dismissed in the disciplinary proceeding. Lordship, you may see page 6, we have narrated everything, the details also. Para 6, but the dates we have given. He has preferred an appeal against the order of dismissal, that has also been rejected.
Oh, I see.
Para 6, towards the middle portion.
And at the time of hearing the writ application, it is found that Annexure 8 is pending before the government. No. That has not been disposed of.
But now,
and yet that has not been disposed of, representation is still pending. Whether she is entitled to get the benefit or not.
How can she serve? It's a dismissal means no question of pension.
We have annexed that rule.
You see, the impugned order of the single judge directing family pension to be paid to the respondent on the death of her husband, who was a government servant, along with simple interest at 8% per annum, is the subject matter of the present appeal. Paragraph. This court has heard the submissions of learned counsel for the appellant as well as learned counsel for the respondent. Paragraph. In the writ, it is seen that the writ petition was disposed of by the single judge on the very first date of listing, without waiting for any reply from the present appellant, and directing and giving the above directions only because representations made by the respondent were purportedly pending with the government for a long time. Paragraph. Had an opportunity been given for filing of a reply, it would have become evident that she was not even, her husband was not even entitled to pension in the first place, since consequent upon his conviction in a criminal case under the NDPS Act, right? under section 20 bracket D bracket Roman small 2 bracket capital A of the NDPS Act, he was in fact dismissed from service. We'll stop that. Against the dismissal order dated 6 July 2009, the husband of the respondent had filed an appeal, which also came to be dismissed on 5/10/2009. These facts are unable to be disputed. The counsel for the respondent. Full stop. In terms of Rule 33 of the OCS Pension Rules 1992, there was no question of the respondent's husband being entitled to any pension. Full stop. Consequently, the appeal order of the civil judge is hereby set aside. The writ appeal is allowed, no order systems.
Item 67.
My lord, 67, I am on behalf of appellant, I am filing rejoinder.
So it's a writ appeal. Last opportunity to file a rejoinder for the next date. Okay. A rejoinder has been handed over in court today. The list on 29th August.
Item 68.
My lord, interim order may be continued. My lord.
All right, interim order.
May I please, your lordship? Lordship, I kindly see order dated 20th of September 22.
Yes. Yes, maintainability.
My lords, I placed those judgment because your the lordship had raised the question of maintainability.
Yes.
I'll satisfy your lordships on that first, my lords. Your lordship may take the first judgment, that is 2011 full bench judgment of Bombay High Court, which has been referred to in your lordship's order. At page 98 of that judgment.
No, actually, you have to also consider the full bench of this court, which is affirmed by the Supreme Court.
There is a division bench of this court. There is a
full bench. There's a full bench of this court.
In fact, they have all followed 1955 Supreme Court Constitution bench. That is the genesis.
No, have you seen the full bench of this court? That was affirmed by the Supreme Court by a detailed judgment. Both the judgments are here. Flagged. You see this. And that's been affirmed by the Supreme Court. You may want to study that. You see, counsel for the, Mr. Mukherjee learned senior counsel for the appellant states that he will examine the decision of the full bench of this court in Mohammed Saud, which has been affirmed by the Supreme Court in and advance submissions from the next date. List on 29th August.
Item number 69.
Interim order to continue.
Item 69. Sir.
May in this
My lord, order dated 4/4/2023.
I pray 1 week. In this case, I pray 1 week for complaints of the
My lords have a look to dated 4/4/23.
That I am submitting.
That was the third time your lordship have extended it.
This order will be complied by.
And paragraph 4 may kindly be said at the
and
IAS disposed the direction issued, etc., will be complied with positively on or before 24th of April 2023.
Yes, my lord, that I have seen my last chance, your lordship. And that is under process, my lord.
What is under process? Everything can't be under process all the time.
Only 7 days, but if failing which your lordship will.
Who has to do it?
The RCCF to do it, but the government has.
RCCF.
My lord, Regional Chief Conservator of Forest, that is under.
Mr. Kuntia states that the file is single quotes under process and assures the court that the compliance will be
only 1 week, my lord.
Within 1 week from today, that is on or before. 11th, no, on or before 10th May 2023. Based on 11th May 2023, if the above assurance is not adhered to, the Regional Chief Conservator for us.
My lord.
Where is he? Bhubaneswar.
No, RCCF, my lord. Your lordship may say that PCCF it would better, my lord, because
the Principal Chief Conservator for us shall remain present online.
My lord.
Based on 11th.
Item number 70.
Item 70. I only pray, my lords, yesterday I was ill. I had also requested the learned Advocate General that I wanted some time here. Next week, any day, your lordship, subject to your lordship's convenience. I want your lordships to hear this matter because it has been remanded from the Apex Court for the Honorable Chief Justice to hear the matter. It relates to telemedicine, which has been approved by WHO, my lords. It's in public interest, actually. Actually, because of my illness, my lords, I'm next week or any day subject to your convenience, your lordships may take up the matter.
All right. Mr. Khan, your senior counsel states that he has been found unwell and seeks an adjournment. Where is the Supreme Court order here?
My lords, it is that last order, the Apex Court's order has been quoted, my lords.
Oh,
can I hand over the copies?
Yeah, we request the chief. Correct. Before a bench. Okay, okay. But this is fine. All right, all right. July 2019. No, it's there. I've got it.
Yes, yes.
July.
Lordship, please. Along with item 7, your lordship.
Item 7 is tagged.
All right.
Yes, as your lordship, please. I'm deeply obliged.
Sorry to disturb your lordship. Item 68, lordship fixed to the date could not follow, my lord.
29th August. 29th August.
Oh, it's okay. All right. All right.
Number 1, CRLMC 1227 of 2020. Item number 2, CRLMC 1233 of 2020.
None of this.
Item number 3.
Same.
Item number 4.
Same.
Item number 5.
Same.
Item 6. Item number 7.
7, my lord, we are appearing opposite party, Union of India.
Or none appears to the petitioner. Dismiss on opposition.
Item number 8.
None appears dismissed.
Item number 9.
I'm an exclusive privilege holder, my lord. On a particular date, the first day of Janta curfew imposed by the Prime Minister, I kept my liquor in a place which was not authorized, for which I have been fined with a sum of rupees 2 lakhs, my lord, which I have deposited. Now, for the same allegation, I am being prosecuted, my lord. Criminal case is not made out. If you will also see the order of the learned session judge releasing the liquor in my favor, he has categorically held that I was a licensee. I had purchased from the beverage corporation, and because of the Janta curfew, I could not keep the in my godown. I had kept it in the next room, my lord, for which I had also sought for permission. That permission could not be given to me because of the corona period, my lord. And I have been imposed with a fine of rupees 2 lakhs, which I have deposited, my lord, under 64C of the Excise Act, my lord. So for the self-same allegation, my lord, a criminal case has been instituted. Prima facie, it doesn't make out a case, my lord. With due respect.
Lord, in this case, charge sheet has already been filed.
Then you can plead for discharge, sir, permitting the petitioner to raise all pleas in the appellate jurisdiction. Petition is dismissed. Or
Item number 10.
We raise point regarding sanction, we'll take in the course of trial.
Correct. Permitting the petitioner to proceed.
Right. Item number 11.
None appears dismissed.
12.
Item 12, no instruction, my lord.
No instructions dismissed.
Item 13.
None appears dismissed.
Item 14.
Same order.
15.
Same order.
Item number 16.
May I please, your lordship?
Yes, please.
My lord, the petitioner has lodged an FIR under section 498, 323, 294, 506, and 4 DPX against the husband. In the meantime, charge sheet has been filed, my lord, but the dowry article was not seized, for which is the petitioner filed a petition before the SDGM Sambalpur for the seizure of the dowry article, because all her certificates are with the husband. And CGB's engineering student is unable to apply for a job anywhere, my lord, for which is filed an application which has been rejected by the order dated 27/7/2020, my lord, at page 21 of
Let's
the.
read that.
My friend to seize those article only, my lord.
My lord, the informant refused to receive the seized articles, my lord. She has already stated in an application before the IO, my lord. She is not.
Where is that? Why don't you file it as an affidavit?
Yes, my lord. Only the documents are with us.
All right,
only
Mr.
your lordship may give 7 days time to
All
file.
right. Counsel, learned standing counsel states that within 7 days he will file an affidavit giving the complete facts regarding seizure of the dowry articles. Advance copy be served on counsel for the petitioner. This for the roster bench on 21st June.
Item 17.
None appears.
Item number 18.
On item 18, it was once disposed of by Honorable Justice R.K. Patnaik, my lord.
It's all right. What is it? Already disposed of.
My lord, once disposed of by Honorable Justice R.K. Patnaik. In criminal miscase number, LMC 2630 of 2822.
All right. This before justice. It is stated that a similar criminal MC number
LMC 2630 of 2022
was disposed of by Justice R.K. Patnaik on
10/10/2022.
On 10/10/22. Let's go for the same bench. On 22nd June.
Item number 19.
Lordship, in item number 19, 20, and 21, there is the same petitioner, my lord, arising out of different PS case number, but the occurrence is the same, my lord. Their protest was the peaceful democratic manner for a public cause, and unfortunately some miscreant taking the advantage of concurrence indulges in an illegal act, my lord. Here the challenging the cognizance order, my lord. Here my small prayer is that kindly clubbing the 3 matters, my lord.
That you can pray for the district judge. Sir.
No, arising out of different case number and registered in the same day, my lord.
That is not even the prayer in these petitions. Prayer is for quashing. Permitting the petitioner to raise all pleas at the appropriate stage. The petitions are disposed of.
Kindly expedite trial, my lord.
That you can. Yes, case of trial, sir. We're still at the cognizant stage. Right.
Obliged.
Item 22.
May I please, your lordship, permitted to withdraw.
Dismissed as withdrawn. Put the prayer clause.
Item number 23.
Raised to all the points after permitting the petitioner to raise.
Item number 24. Item 25.
Well, 25 permitted withdrawal.
What? Dismissed as withdrawn.
Item number 26.
None of this dismissed.
Item number 27.
27, sir, pray for one passover.
Item 28.
None of this dismissed.
Item number 29.
Item 29, petitioner died in the meantime, lordship.
All right. Stated that the petitioner has died. Dismisses having abated.
Item number 30.
So item 30 marks raise all the points before the trial court.
All right. Permitting.
Item 31.
None of this dismissed.
Item number 32.
Raise all the points after permitting the petitioner to raise all.
Item number 33.
None of this dismissed.
Item number 34.
Same one.
35.
Lord Duff, may I please, your lordship?
Yes, please.
Lord, page 30 of the brief, your lordship may kindly turn to. It's a dispute of purely civil nature and it has been compromised. Lord, it's a contract basically between a builder who is the informant, the complainant in a 1cc case. I have already paid, my lord. It has been compromised. That is also reflected in the law and sessions just order while releasing him on bail. So that is, my lord, page 30, your lordship may kindly turn. After payment of the aforesaid amount, the first party requested the second party to reconsider and modify the terms of the agreement. The second party accepted such request of the first party and on consent of both the parties. The terms.
Mr. Acharya and senior counsel for the petitioner states that the parties have in fact settled their disputes and payment has also been made by the petitioner to opposite party number 2. We say notice returnable before the roster bench on 1st August. There should be stay of further proceedings in
In CT case number.
Yeah. No, we'll take from the prayer clause. All right. Till the next day.
But I'm
36.
Item 36, my lord, permitted to raise all points before
all right.
Lower court.
All right. Permitting the petitioners.
37.
37, my lord, this is relating to a COVID incident. If my lord would see page 30, the BMC complains about a news item which was uploaded in the website. If the transcript we are giving, my lords, we have given that in Odia, we are giving in English now. We have also got a brief submission that flag B. Even if these allegations are accepted at face value, no case is made out. It's basically against the freedom of press. They have tried to rein in. I'm giving the transcript of the conversation between two friends which was uploaded. So absolutely nothing is made out, my lords.
In this case, investigation has not been completed. It is also going. Investigation.
Why get into all this? This is,
my lords, in fact, they should not have registered the case.
Freedom of the press, my lord, is restricted to a reasonable limit. So far as the
what is unreasonable? Show me. You've given a copy.
Yes.
What is unreasonable here? You tell me. What is the objectionable
Well, in pandemic situation, these two persons created more panic in the
Panic? No, no.
Well, they were discussing one should not be afraid of COVID-19 because in the COVID center they are being provided with the hotel food, etc. Well,
Yes.
Create those talks, my lord, between the two friends, my lord, was made video viral in the OTV, my lord. So, Lordship may kindly see page 32, that is the OTV logo that has been annexed by the petitioner, my lord. And also it has been admitted in, your Lordship may kindly see paragraph.
Are you sure this is a perfect translation?
Yes, yes. We have given the transcript and the ODR we have given them.
No,
Yes,
why don't you places with an affidavit?
My lord, we would do that. My lord, all that I would submit, my lord, if the transcript is actually seen, it's actually saying that there is nothing about the disease, you shouldn't fear it. In fact, that's what the entire conversation is between two friends.
The senior advocate has referred to Bhajan Lal case. My lord, in the case, first guideline principle that the no prima facie case, if no prima facie case is made out. My lord, here in this case, in the FIR, my lord, there are sufficient materials against the OTV, my lord. Therefore, let's see all these defense may be raised at the time of trial.
Placed before the court, handed over to the court an English translation of the transcript of the conversation between the two persons, the video clip of which is the subject matter. The video clip of which was aired in the television channel of the petitioner. No, television channel of which the petitioner is the single quotes input editor. Full stop. The said the English translation be placed on record with an affidavit certifying to its authenticity. Full stop. List before the roster bench on 21st June.
Item number 38.
In fact, we have given the pen drive also, which is a part of the court record.
Item number 38.
None of is dismissed.
Item number 39.
None of is dismissed.
Item 40.
My lord, petitioner is expired, my lord.
All right. The counsel petitioner states that the petitioner is expired.
Permitted to file a substitution?
No. Dismissed as
Or liberty to file face, sir?
Not necessary, sir. Yes. All right.
Item 41.
None of is dismissed.
42.
My lord, CRLMP be delisted. The CRLMP has no connection with the CRLMC.
All right. You are appearing the CRLMP.
CRLMP.
CRLMP be listed before the roster bench on 1st August. All right. CRLMC is your non-appeal.
Item 43.
Non-appeal is dismissed.
Item number 44.
Same order.
45.
Same order.
Item 46.
Same order.
May I please, your lordship?
46.
I filed one petition for adding the informant as opposite party number 2 to date cell. Your lordship may kindly come to the annexure. I have received the information under RTA Act, page 56, annexure 6. The informant who lodged the affair, she is at her school during the occurrence. The incident was occurred at 7 a.m. The affair was lodged.
Why don't you say what the offences are, sir?
Milord, your lordship has passed the similar matter yesterday, item number 68, 1339 of 2020, where my Lord Honorable Justice Mishra was passed the interim order, a similar matter, my lord. where your lordship directed
What is the
to serve
offence?
additional affidavit to the informant who has entered appearance through through her advocate.
What is the offense?
My lord, your lordship may kindly come to the
Am I audible to all of you?
offense is 341, 323, 294, 427, 354. The informant is not present at the time of occurrence. She is at her school. She gets the CL 2 p.m. and lodged the affair thereafter. The incident was happened at the time of at 7 a.m. morning. Undated 2/1/2020.
Anyway, this is going on for the last 3 years, sir. Permitting the petitioner to raise all pleas at the appropriate stage. Petition is disposed of. All right.
47.
A little similar, madam.
Same. All right.
Item 48.
None appears dismissed.
Item number 49.
Same.
Item 50.
Same one.
51.
51, my lord, just covered by the judgment of this honorable court. Apart from that, regarding that non-compliance of section 71 of the 71 subsection 3 of the Odisha Excise Act, my lord. What fact means the annexure 2 at page 11, your lordship, non-production of the vehicle before the confiscation authority is also barred under subsection 3 of section 71.
The vehicle is still seized.
Vehicle auto rickshaw has been seized.
No,
And
what
that has
what
not
vehicle
been
is this?
produced.
What vehicle is this?
That is auto rickshaw.
And it's in some police station now.
No, it is in the police station. It should have been produced before the current authority who was seized.
What's the current status you find out?
Yes, ma'am.
Counsel for the state will find out what the current position of the auto rickshaw in question is and inform the court on the next day.
Yes.
Let's turn 28 June for the roster bench.
Item 52.
52 not pressed, madam.
Dismissed is not pressed.
Item 53.
None appears dismissed.
Item number 54.
Same.
54, may I please your lordships, my lord. My lord, I am challenging the cognizance order, my lord. My lord, if your lordships permitted me to raise these points at the time of charge.
Correct. All right.
Obliged.
55.
Sir, my lord, challenging the proceeding under section 52A and 55 of the Odisha Excise Act, my lord. What happened in this case, my lord? Alleged occurrence second place at morning hour. At evening hour, 5 to 6 kilometers away, one person was moving, police caught hold, excise police caught hold and recorded his statement. This petitioner is no way concerned, my lord. On the basis of statement of that person, there has been.
All right. You point out that permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item 56. 56.
None appears dismissed.
Item number 57.
May I please? Challenging the issuance of NBW, my lord. NBW issued on Equistio 21/6/2022, my lord. Thereafter, he was released on bail 23/7/2019, my lord. This is a case of Belgium, my lord.
363, 366.
My lord. Earlier, he was released on bail, my lord. Due to his non-appearance, my lord, NBW has been issued, my lord. I have only challenged the issuance of NBW, my lord.
No, not inclined. What
He was on bail, my lord, during trial.
That's all right. What do you wish to do?
Permitted to withdraw.
Dismiss is withdraw. All right.
Item 58.
None appears dismissed.
Item number 59.
May I please, my lord? Challenging the order of taking cognizance, my lord. Initially, the offense, alleged offense in tribal by London magistrate, and thereafter 376 added against the petitioner number 1, my lord. Due to marriage proposal was broken, my lord, and the petitioner number 1 also serving in armored force, my lord. The order of taking cognizance without sanction 197(2) of this.
All that you can take at the appropriate stage. permitting the petitioner to raise all these pleas at the appropriate stage.
I am the respondent.
Yes.
Item number 60.
None appears.
61.
May I please, Your Lordship? My Lord, here the petitioner is challenging the order of cognizance dated 1st February 2022 for the alleged offence under section 341, 323, 427, 506, 307, 34. What happened in the meantime? There is a matter amicably settled.
I have appeared for the government, and the matter has been amicably settled, and I have filed an affidavit to that effect before the Oath Commissioner of this.
Who's the informant? Where's the affidavit?
My Lord, opposite party number 2. My Lord.
All right. Counsel appearing for opposite party number 2 confirms the affidavit filed, in which he states that he does not wish to pursue the criminal proceedings and will have no objection to the prayer being allowed. In that view of the matter, take from the prayer clause and all proceedings consequent thereto by court. All right.
Obliged, my Lord.
62.
My Lord, 62 permitted to withdraw.
Dismissed as withdrawn.
63.
My Lord, on behalf of Mr. Sambe Saman, we want to withdraw this case.
Dismissed as
Thank
withdrawn. All right.
64.
64, my lord. I have challenged the order of cognizance. Your lordship, permit me to raise those points before the trial court at the appropriate stage.
Raise all, please. Correct.
Item 65.
65. Yes, earlier the petitioner was on bail. Lordship may kindly turn to page 12. He has been granted bail by this honorable court, and subsequently, due to want of proper instruction, my lord, so the learned counsel, your lordship may kindly see page 14, order dated 19 to 2018.
376, sir. 376. Dismissed as withdrawn? Dismissed as withdrawn. Right.
Item 66.
66, I beg kindly taken up next week. There is some defect, my lord.
All right, tell us what it is.
That is order of NBW under challenge.
What's the offense, sir?
Offense, my lord, 395 and 25 and 26 answer.
Dismissed as withdrawn.
Lordship may permitted to withdraw, my lord.
Dismissed as withdrawn. Yeah.
67. 67.
None appears dismissed.
Item number 68.
Item number 68, lordship, matter has been compromised between the parties, the informant and the injured person. So far as the concern of the present petitioner, he is the owner of the vehicle who make an accident. He is not inside the vehicle, lordship. And so far the concern, the allegation 307 is the minor.
Give it to him, sir. You've not made him a party. You make the informant a party. An affidavit to the informant has been handed over, but the informant is not a party. Counsel for the petitioner will take steps to include him. Meanwhile, the advocate for the state will verify if the affidavit is genuine. This before the roster bench on 22nd June.
Item 69.
May I please, your lordships? This is for quashing of the criminal proceeding against the petitioner. The petitioner may be kindly permitted to raise all the grounds.
All right. Permitted the petition.
Item number 70.
My lord, item 70 involved the charge sheet not pressed.
Not pressed. All right.
71.
Please, your lordship. My lord, yes, of 13(2), 13(1)(c)(d), 420, 468, 471, 477A, 34 of Indian Penal Code. FIR registered, my lord, in the year 2018. Till now, my lord, charge sheet has not been submitted.
Because it's pending, that's the only reason, sir. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed. Right.
Item 72.
My lord, approved.
72, sir.
Item 72, your lordship's liberty may kindly be granted to resolve.
Permitting the petitioner to raise all pleas.
Item 73.
73 not present.
Not pressed. Dismisses first.
74.
May please, your lordship. The application for questioning the order dated 1/10/2020 passed by the DJ Gunupur
Allegation of offence is 188, 272, 273, 20 of Cigarette Act and others. Illegally procured huge quantity of cigarette and stocked in his godown at Melbourne. Your Lordship, set aside the order passed by the learned additional district judge and dated 1/10/2020.
Huge quantity, man. Gutka. Permitting the petitioner to raise all pleas to the appropriate station. Petition is disposed. All right.
75.
May it please your lordships. My lords, though the notice was issued in February 21 and stay was granted, now, my lords, my instruction is the matter has been compromised between the petitioner and the informant. So
you file the affidavit then?
I'll file detailed papers, my lords. You may keep it to after vacation.
All right.
31st of July, preferably your lordship is giving that date.
31st July. All right. Learned Senior Counsel to the petitioner states that the matter has been compromised. He states that the affidavit of opposite party number 2 will be.
And also the order sheet of the learned court below. Order sheet has also, my instruction has been recorded in the order sheet also.
Including the recording, including the copy of the order sheet of the trial court will be placed before the court by the next date. List on 31st July.
Interim order to continue.
Item number 76.
76 may I apply? Please, ma'am. Your my lord, the proceeding and the order of cognizance dated 6/3/2018 has been challenged on the ground that the company was not made as a party. Lordship may kindly peruse the recent dictum of the Honorable Apex Court in the case of Krishna Murari and Bella M. Trivedi. I am giving the copy of the
check was issued by whom?
Check was issued by the present petitioner in the capacity of the managing partner.
Where is that?
That is, Lordship may kindly peruse page, the instrument I have annexed.
That company.
Page 11, Annex 2.
All right. It is seen that but has notice gone to the other side?
He has notice gone to the opposite party, my lord. On two times he has not appeared for the last 2 occasions. Interim orders are there, but he is not appearing. Lordship may kindly peruse the recent judgment, my lord.
That's right. All right. You see, it appears that the check none appears for the opposite party number 2 despite service of notice. It is seen that the check in question was issued on behalf of the partnership firm Messrs. N. Parida and Company.
B.N. Parida and Co.
B.N. Parida and Co. of which the present petitioner was the managing partner. So, however, in the complaint, the said firm is not been arrayed as an accused. Paragraph. In view of the judgment of the
that is 2023-89 OCR Supreme Court 405. Pawan Kumar Goyal
was the state of UP. 2023-89 OCR bracket SC 405. The complaint is not maintainable as such. Consequently, taken to prayer clause and all proceedings consequent thereto, who are the present petitioner, stand quashed.
Obligation.
77.
Please, your lordship, during the pendency of the case before this honorable court, a settlement was made by the George Family Court, Sambalpur, and the petitioner deposited
the affidavit of the
demand draft of rupees 20.
Joint affidavit should be filed in this case because he is the husband praying for the quashing of the proceeding. And just now I came to know the husband deposited 20 lakhs in the conciliation proceeding. My lord, they have my instruction, they have deposited before the family court, but the complainant, OP number 2, not received that amount. and not yet passed the complete process.
I see. All right. At the request of counsel for the parties, list before the roster bench on 21st June.
My lord.
All right.
Item 78.
78, my lord. This is a case under section 138 of NI Act. Company has not been made a party.
All right.
Page 8, para 2. The accused is a director of AMF Group. But AMF Group has not been made party.
All right. The check in question was apparently issued by on behalf of the company. Which is the item? 1531.
Sorry, 71. My lord, 1522.
Right.
1522.
Right. The
Page 7
question
complaint petition.
was apparently issued. No, where is the check, sir?
My check was issued by the director as the director of the company. Page 8, para 2 of the complaint petition. That the accused being the director
What is the company's name?
Company AMF Company. AMF Group of Companies. Company name is AMF Group of Companies.
Can't be like that, sir. Company name has to have a limited or something. Can't have group of companies.
AMF Group of Companies.
Can't be, sir. Have you seen the names of companies? There has to be limited at the end of the company's name.
But that has not been made as a party.
No. Where is the check? Where's the copy of the check? You bring a copy of the check, then it will be clear.
Copy of the but in the complaint petition, he has written that he has issued the check as the director of the company.
There is one AM Fund Managers Limited. So was it?
He has issued the check as the director of the company.
Which company, sir? Company's name can't be group of companies. Give me the name of the company.
In the statement, he has also stated in the initial statement the group of AMF Group of Companies.
No. Sir, I don't know whether you've seen the check here. Have you seen the check?
I am at check is not with me.
You find out.
Madam?
You find out, sir.
Let it come after vacation. I will obtain the certificate.
At the request of counsel for the petitioner who wants to produce photocopies of the checks in question, of the dishonored checks in question, list on 28 June.
28
June.
Interim order to continue.
Interim order to continue.
Item 79.
None appears dismissed.
Item number 80.
Same order.
Passed on matter item 27.
Item 41, my lords, may be permitted to withdraw.
41. Dismiss is withdrawn.
Item 27.
If PD Lordship may kindly liberty may be granted to raise all the
pleas. All right. All right.
On 30. The government has not sought copy of those affidavits.
We have got a copy, my lord. Yesterday we have got a copy. Lordship, but your lordship's direction on the last occasion was to, my lord, identify the municipalities wherein they have entered into an agreement with those contractors and to ensure that the safety provisions are there in the agreement itself.
Correct.
But the affidavit does not disclose the same, my lord. And in the meantime, my lord, I also wanted to bring to your lordship's notice that the central government has also come up with a national action for mechanized sanitation ecosystem, giving all the details, my lord, that how there'll be mechanized cleaning of sewers and septic tanks, eliminating all forms of manual scavenging, my lord. So, lordship, may kindly see the affidavit, whatever is filed, my lord, by the government, my lord, lordship, may kindly see, my lord.
Your lordships, in that affidavit, one thing they do agree that the central government had communicated them under Annexure A. Your lordships will see this affidavit filed by OP 1 and 2.
Flag 140.
Yes, by Durgesh Nandini Sahu. At Annexure A, they do, which is in fact, the following page, your lordships will find that there's a letter from the central government, 17th December 2018, where they have communicated both that SOP and the manual on sewerage and sewage transport system 2013. What they have done is they have they've communicated. But in pursuance of the order of your lordships, what they were supposed to show the court, that in the contract the terms are them. What they've done is there's only a table and they have named some people, no address, nothing. And this person is doing sewage killing. Yes, they have been communicated. It's not mere communication. If it was a mandate, then the incident cutter would have never happened. And what they have done is, they have also cited that some SOP which they have made. Your lordships, that SOP is only a training SOP. This is how the checking has to be done. What is the gas level? Everything. What happens on spot in case of an emergency also. Nothing of that sort, your lordships.
No, this Annexure C says setting up of emergency response sanitation unit and its functioning. So this is apart from what they engage as agencies, or this is those agencies?
No, your lordship, this is an agency that this came up after after this PIL. They have set up these bodies. They said these are telephone number. You'll have an attendant. You'll have a top man, which is a little in consonance with the rules. But the SOP, your lordships will have a look at that SOP. That SOP is very detailed. That SOP is not, it's not, your lordship, that SOP was filed on the last date. This is about how they will train people on doing it. What are the... it's very general. But your lordship, look at that SOP which was there last time. Flag. Oh, flag. It was filed on 2/3/2023. See, flag. That must be flag 120. Not flag 120.
120
No, 120. It's not showing. It's not showing. It's not showing the list.
Flag?
Your lordships, that's not showing on the list which flag, but must be prior to 120, your lordships.
That SOP?
That SOP.
All right.
That SOP, your lordship, if I be permitted, just read it out. Then your lordships probably will Just for example, step 3, ventilate the sewer line by opening 2 or 3 manholes on both sides of the working stretch for at least 3 hours prior to starting the work to ensure escape of toxic gases. The worker opening the manhole must not bend down into the opened manhole, and this may cause his getting overcome by the hydrogen sulfide and even tripping into the manhole. Things like this, Your Lordships.
No, but what we don't know is whether those agencies have been mandated to provide.
Yes, and that is what they have not made a disclosure about.
Yes, Mr. Mudali, that was what had to be told. See, each of the bodies would have entered into various agreements with agencies.
Yes.
In those agreements, you have to incorporate these things as mandatory requirements.
Because certain agencies have included, but those documents have not been enclosed. I will enclose some agreements so that it will be factual.
And then what are you doing to follow this national action plan that you have to take?
The recent one.
I
will obtain.
You see, 3 affidavits have been filed pursuant to the order passed to this court on 2nd March 2023. Full stop. 2 of the affidavits are by Sri Tripti Ranjan Nayak. One is by Sri Tripti Ranjan Nayak, who is the inspector in charge of the Badagada police station, who inter alia states that in relation to the incident,
may I take a lots of 1 minute time?
Registration of Badagata case number 0167/2021 dated 29 April 2021. A charge sheet has been filed against accused Ashok Kumar Sahu, manager Watco, on 17th April 2023 upon completion of investigation under section 304A IPC. Full stop. The second affidavit is by Sri Tapas Chandra Pradhan, Assistant Commissioner of Police Zone 3 Cuttack, who states that in CDA Phase 2 PS case number 33 of 2021 dated 18th April 2021, a charge sheet has been filed against Pradyot Kumar Sahu and Deepak Kumar Nayak under section 304 capital A/34 IPC /9 Prohibition of Employment as Manual Scavenger and their Rehabilitation Act 2013 and sections 3(1)(j /3(2) Roman small 7 of the SC/ST POA Act. Paragraph. A third affidavit has been filed by the Additional Secretary to the Government, Housing and Urban Development Department, placing and record the various instructions issued from time to time to all the ULBs and municipal corporations on the requirement of taking precautionary and safety measures for persons entrusted with the task of clearing manholes and sewer lines. It is pointed out by the full stop. The affidavit also talks of the setting up of emergency response sanitation units (ERSUs) headed by a responsible sanitation authority (RSA), which is stated to have been set up in all the 115 ULBs in Odisha. Paragraph. It is pointed out by the learned amicus curiae that the specific requirement, the specific direction in this court's order of 2nd March 2023 was for the state to place before the court for the court to be the state to inform the court whether there is strict compliance with the various agencies with the SOP and training manual prepared by CPHWEO of the Ministry of Housing and Urban Affairs, Government of India, and open quotation, whether the strict compliance thereof has been made one of the mandatory conditions of the contract entered into with the agencies and the consequence of non-compliance with the said condition. Unquote. The affidavit filed does not answer the above specific direction. Full stop. Mr. P. K. Mudali, learned additional government advocate, assures the court that before the next date, an affidavit will be filed specific to this issue, namely whether the agreement with the agencies deployed for undertaking the work of cleaning of manholes and sewers incorporate as mandatory conditions the elements, the constituent elements of the SOP and the training manual. Paragraph. The learned AAC have also placed before the court a copy of the single quotes National Action for Mechanized Sanitation Ecosystem, unquote, brought out by the Ministry of Social Justice and Empowerment, Government of India, and a copy of which is already available with the state of Odisha. Full stop. The affidavit to be filed with the state before the next date will also state whether the above single quotes national action unquote plan is being followed in the state of Odisha.
Lordship, I would like to Lordships to go through Lordship's last order, but Lordship in paragraph 8 had categorically stated, my lord, that the court would like to again emphasize that unless there is a strict implementation of the Act 2013 by prosecuting the offences committing thereunder, real tangible changes cannot happen on the ground. Lordship, may kindly see the affidavit which was being filed by the DCP, my lord, Bhubaneswar, my lord. As your Lordships remembers that there is a LC Infra Project Limited at Bhubaneswar, which was executing the project. While charge sheeting, my lord, he has not been charge sheeted. Who has been charge sheeted, my lord, is the executive engineer. Whereas the LC Infra project, whom they had given a report before this honorable court, stating therein that they were the people, those who are executing the project. It is they who had employed those people. Now that person has been completely scot-free, whereas the executive engineer has been, my lord, made only as only accused person. Not to may kindly see the annexer A, that affidavit which is being filed by the Deputy Commissioner of Police Bhubaneswar on 19/4/2023.
The IO contacted Ashok Kumar Sahu and he admitted his guilt. So they only got hold of the manager, Watco. So they did get a report of the project manager, LC Infrastructure.
While in page 16, they themselves are written, let's may kindly come to page 16. During the course of investigation, IO has examined the complainant, visited the spot, examined witnesses and seized the documents relating to this work from the complainant. In course of investigation, it has been ascertained that on 19/3/2021, on the written reports of Sri Jogesh Kathua of project manager LC Infrastructure, Baragarh PSUD case number were registered regarding the death of its worker of LC Infrastructure Private Limited, namely Sulubu Birua of so and so, and all those persons' name.
So this Ashok Kumar Sahu admitting his guilt is the key thing. We don't know what. So what man? Anyway. So when do we list it?
In the contract, they are not.
Yeah, correct.
That is why they are not able to take action against this after you.
July.
In fact, this submission itself shows that in the contract they don't have the provision. That is why they're not able to take action against them.
LC infra, correct. All right.